track record, if you will, history and tradition of these sorts of broad prosecutors. So I think you could write an opinion limiting it to basically Smith, Mueller, Ron Hur, and maybe a couple others, and leave the poor DAGs and the deputy SG in peace and quiet.
Matthew, after U.S. v. Trump, Justice Sotomayor and other critics of the majority suggested that it would make the Nixon prosecution itself difficult to introduce evidence of the tapes. To what degree is Judge Cannon's opinion and Justice Thomas's separate opinion part of a broader questioning of the legitimacy of special prosecutors against the president that might call into question the whole Watergate prosecution from beginning to end?
I think there are two ways to think about the collection, the array of decisions that you're talking about that are broadly skeptical of the prosecution of a former president here. One is that there is a potentially ideologically or politically motivated perspective that's driving a variety of different cases. Another is that these issues simply haven't been presented before because this is the first time we've had a former president who's been prosecuted. Different people are going to read these trends in different ways. I think it is certainly the case that the immunity decision would render the prosecution of Richard Nixon unlawful. And the reason is because, the conduct that Nixon would have been prosecuted for, he resigned and was ultimately pardoned by President Ford. And so this never came to pass. The question was never presented. But everybody at the time assumed that Richard Nixon was going to be prosecuted. And the thing that he would have been prosecuted for is using the levers of government for his own criminal political purposes, including using the Department of Justice, the FBI, the CIA. Those are exactly the types of presidential official actions that are core executive functions, according to the Supreme Court, for which a president is absolutely immune. So I think there's no question that the Nixon prosecution the hypothetical Nixon prosecution would have been completely blocked. So maybe Richard Nixon, shouldn't have resigned after all. Now, another important caveat to what we're talking about here, though, in the appointments clause issue is that the Mar-a-Lago classified documents case does not go away if Donald Trump wins on this issue in the Supreme Court. And the reason is because it doesn't go to the legal or factual soundness of the prosecution. It goes to this procedural question about the constitutionality of the special counsel's appointment. So let's say it turns out that the Supreme Court says, no, Special Counsel Smith, you never really had a job. You were unconstitutionally appointed. Indictment dismissed. Okay, he can be re-indicted by the U.S. Attorney for the Southern District of Florida the very same day, and this case goes ahead, and there's absolutely no question of the lawfulness of the appointment of the U.S. Attorney for the Southern District of Florida, who was appointed by the president with the advice and consent of the Senate. So this is a procedural issue that even if former President Trump wins, it does not make this case go away. And I think that's important context for something that Jeff brought up before. These constitutional issues are supposed to be decided in a political vacuum. It's difficult to really completely isolate the issues from the context here. And that context is that, holding aside whatever you think about the January 6th case, which does deal with novel factual circumstances and therefore novel applications of federal criminal statutes, the classified documents case is really a run-of-the-mill classified documents case. It happens, many times a year, where people are sent to jail for decades. And there's absolutely nothing that has happened in Judge Cannon's courtroom, including in this decision, that casts any doubt about the ultimate soundness of this prosecution, which means that the stakes of the election for the former president are whether he will face trial or not for unlawfully retaining national security secrets.
Josh, do you agree or not that the immunity decision would render the prosecution of Richard Nixon unlawful, and that this is part of a broader skepticism of the Watergate prosecutions? And do you agree that if the Mar-a-Lago case doesn't go away and that President Trump could be reindicted by a U.S. attorney?
Yeah, I actually wrote recently that I think the Trump immunity case called into question the Nixon decision. I'm not so sure the case was correctly decided. I mean, remember, it was decided in a very compressed period, in a very toxic, volatile time. The nation was kind of on a razor's edge. And the court made a lot of sweeping assertions that were sort of then limited to these unique facts. This word unique keeps appearing. To use one example, only a couple of years after Nixon, the court decided Buckley versus Vallejo, which is sort of the birth of the modern appointment clause jurisprudence. There's tensions between Buckley and Nixon that were never resolved. I think there's serious problems with Nixon. There was actually an op-ed in the Wall Street Journal about a week or two ago saying Nixon shouldn't have resigned. He maybe could have held out. Maybe it was. I wasn't around. I can't really tell. But I think the precedent has been sort of vitiated. And this point might not be popular, but I think a lot of this is to blame is the lawfare against Trump for the last 7 years or so. From the moment he got into office, you had the emoluments clause litigation, and you had the Robert Mueller, and all these efforts to try to weaken Trump through the legal process. I think John Roberts said, okay, basta, enough, right? I've got enough of this, right? We need to let politicians be politicians, let the process work itself out. We'll have an election, but stop trying to use the courts to cripple politicians. I mean, I don't want to make this point too bluntly, but on the same day, Jack Smith filed an appellate brief and re-indicted Trump like 70 days before the election. And this is just normal now. This okay, just another indictment, no big deal. I think there's something to be said that this lawfare is dangerous. And I think the immunity decision said you can prosecute perhaps narrowly, and I think the indictment may actually clear the hurdle. We'll talk about that in a minute. But stop the broad efforts to try to criminalize all facets of politics. And that, I think, was lurking in John Roberts' mind when he wrote the opinion he wrote.
Well, it is time for closing thoughts in this excellent discussion of the merits of Judge Cannon's decision. Matthew, first thoughts to you. Tell we the people listeners why you believe that the appointment of Jack Smith was consistent with the Constitution and federal statutes.
So to give my closing argument here, I think Judge Cannon was correct in recognizing that binding Supreme Court precedent categorizes the special counsel as an inferior officer, so neither a principal officer that has to be appointed by the president, nor a mere employee who can't wield this level of prosecutorial power. And so then the question is just whether the Congress has passed a law that gives Attorney General Merrick Garland the power to appoint an inferior officer. And I think that the answer is yes. And the simplest reason why is that 28 U.S.C. Section 533 says that the Attorney General may appoint officials to detect and prosecute crimes against the United States. I have a simple, straightforward interpretation of that. I think that statute gives Attorney General Merrick Garland the authority to appoint Jack Smith to detect and prosecute crimes against the United States. So I think that the statute here is as crystal clear as you can imagine it being, and that gives the Attorney General the authority to appoint special counsels, including Jack Smith, and for that reason, his appointment was lawful.
Many thanks for that. Josh, last word to you. Tell we the people listeners why you believe that Jack Smith's appointment was not consistent with the Constitution and federal statutes.
In a nutshell, Jack Smith is an employee. He's not an officer. He has a position that lacks duration. He's not an officer. Therefore, he can't exercise the significant authority of being a United States attorney.
Thank you so much, Matthew Seligman and Josh Blackman, for a vigorous, illuminating, and superb discussion of the merits of Judge Cannon's decision striking down Special Counsel Jack Smith. Matthew, Josh, thank you so much for joining.
Thank you so much.
Thanks so much for having us.
Today's episode was produced by Samson Mastashari and Bill Pollack. It was engineered by Bill Pollack. Research was provided by Samson Mastashari, Cooper Smith, and Yara Derese. Friends, Constitution Day is coming up. September 17th will be such an exciting day at the National Constitution Center. Our honorary co-chair, Justice Gorsuch, will come to discuss his new book, and we will have all sorts of great activities. Come to Philly if you can. What an amazing time to share with you. And if you're not able to join in person, please join online. Go to constitutioncenter.org for all the exciting Constitution Day activities. And sign up for the newsletter, constitutioncenter.org/connect. And always remember, in your dreams, in your prayers, in your waking and sleeping moments, that the National Constitution Center is a private nonprofit. We rely on the generosity, the passion, the engagement, the devotion to lifelong learning of people like you from across the country who are inspired by our nonpartisan mission. There's so much meaningful learning to do together as the new school year and the Supreme Court term begins, and I'm so looking forward to sharing it with all of you. Support the mission by becoming a member at constitutioncenter.org/membership, or give a donation of any amount to support our work, including the podcast at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Jeffrey Rosen.